but there's a little bit of a problem with it. It came to my attention a few years ago, and we worked with the bill last year, and this is kind of where we've ended up today. A party who had been both a domestic abuser of the wife and a sexual abuser of the children was able to use an ex parte order to get a change in circumstance when the wife and the family did not know about it. And that prompted the idea for this legislation that very simply requires 24-hour notice of an ex parte order granted in a custody case with some minor exceptions. That would be wherein the safety of the child would be in jeopardy. It would require the Judicial Council to promulgate and effect rules related to this by January 2012. Now, we're informed that the Judicial Council is considering that, but I would find more comfort if we had it statutorily empowered and dictated. They can then follow with their regulation. I believe that this would just make a much better situation in such emotional circumstances to allow that one party, very simply, Mr. Chairman and members, to be informed that 24-hour notice. There would be an exemption if there were some other situation that would require a longer notice or even a shorter one based on the circumstances affecting that child. That then could be granted by the court.
Thank you, Mr. Nielsen. First witness in support.
Thank you. Dawn Kepke with McHugh and Associates on behalf of Crime Victims United of California in strong support. We think that this strikes the right balance between allowing notification so that both parties can participate and yet at the same time allowing the exceptions for protection of the child. So for those reasons we support. Thank you.
Thank you. Are the witnesses here, are there any others in support? Are the witnesses here in opposition to Mr. Nielsen's bill? Please come forward. You can use that microphone, sure.
Chair and members, my name is Jill Barr, and I'm the Legislative Director of Association of Certified Family Law Specialists. We oppose the original version of this bill. We find the amended version does not add anything to current law, and the notice provision is vague. Judicial Council is already drafting a rule of court on this, and it seems that we should just await for that rule. Thank you.
Thank you. Others in opposition? Colleagues, questions or comments for Mr. Nielsen? Is there a motion on the bill? The bill's been moved and seconded. Mr. Nielsen, seeing no further questions or comments, wish to close?
I vote.
Very well. Call the roll, please.
Fear?
Aye.
Fear, aye. Wagner? Aye. Wagner, aye. Adkins? Adkins, aye. Dickinson?
Aye.
Dickinson, aye. Silva? Silva, aye. Huber?
Aye.
Huber, aye. Huffman? Huffman, aye. Jones? Jones, aye. Monning?
Aye.
Monning, aye. Wachowski?
Aye.
Wachowski, aye.
Mr. Nielsen, congratulations. That bill has sufficient votes and is out. Now we'll turn to item number 13, AB 1108. Please proceed.
Mr. Chairman, you are well familiar in this committee of these bills, and I go back into the mid-'80s carrying similar legislation, usually meeting similar fates, but one must always keep trying. And I would argue that Dame Justice is both blindfolded to be impartial and is balancing. And that's what this is attempting to do. Maybe a little bit different in this particular bill as we're now trying to apply to the Consumer Legal Remedies Act. And we address a higher requirement for a defendant to receive an award of the court. That be that the plaintiffs did not act in good faith. And I would argue that there should be no presumption of advantage before the court and before the law, and this would remove that presumption of advantage, and I think then again strike that balance of those scales of justice. It creates equal protection under the law for both plaintiffs and defendants. It does not compromise plaintiffs, the formation of classes, the proffering and the conduct of those lawsuits. It does allow the judge to order costs and legal fees to the prevailing party, but unfettered by that extra standard. I would urge favorable consideration.
Thank you, Mr. Nielsen. First witness in support.
Catherine Pettibone with the Civil Justice Association in support of this nice bill. Under the Consumer Legal Remedies Act, the court is required to award the attorney's fees and costs to prevailing plaintiff. However, defendants only get their attorney's fees if they can show a subjective bad faith by the plaintiff in bringing the claim. This bill would allow either party to get their costs and awards, and although this provision, the Consumer Legal Remedy Act, has had a laudable intent and done good work over the years, we've seen it be extended to support claims like your hair isn't strong enough for the shampoo you're using because of the advertising. So we would urge a change that would mitigate some of these claims, and are happy here to support this bill. Thank you.
Thank you for your testimony. Next witness in support. Mr. Nielsen, you have further witnesses in support of your bill? All right, seeing none, witnesses in opposition to your bill? Good morning.
Good morning. Good morning. Brian Kabatek, Vice President, Consumer Attorneys of California. The original law, the Consumer Legal Remedies Law, was enacted in 1970 and signed into law by then Governor Ronald Reagan. It was amended in 1988 and signed into law by Governor Duke Majan, and that was the time that the attorney fee clause that allowed plaintiffs to recover attorney fees if they prevailed and defendants to recover attorney fees if the defendant can establish that the case was brought with a lack of good faith. That was the time it was established. This is a good law. This protects Californians. The law was enacted and came out of a need to protect consumers in the state from business interests and business actions that are fairly widespread. There's no particular need for this law. There's no particular cases cited where there's a need to bring this kind of law to change it with respect to the attorney fees as it now stands. The law does include a safe harbor, as it currently is constituted, where a letter has to be sent before the litigation can be enacted to give the defendant an opportunity to correct its actions. The proposed amendment would have a substantial chilling effect on consumers who are encouraged to bring these kind of actions forward and encouraged to advance these kind of actions to correct business practices in the state. It's an important component for average Californians to be able to bring these types of actions. It's an important part of our law. It stands right up there with the Credit Discrimination Act, the Consumer Warranty Act, and other consumer protection statutes where the prevailing plaintiff is entitled to recover fees, but only actions that are brought in bad faith would allow the defendant to recover fees. So we'd urge a no vote. Thank you.
Thank you very much. Any other witnesses in opposition to Mr. Nielsen's measure? Seeing none, questions or comments from members of the committee? Mr. Dickinson.
Just a comment. I don't want to repeat the testimony we just heard, but it's exactly correct. And I don't speak from a theoretical vantage point here. I was in this type of practice, and there's no question that exposure to attorney's fees for a prevailing defendant will absolutely kill the pursuit of redress for consumers, justified or not, because the balance of resources simply is not the same. And by the way, we're not just talking about individuals. We're talking lots of times about small businesses who may have a claim against another business or a larger corporation that will not be in a position to bring those kinds of cases if they are exposed on the basis that you're proposing, Mr. Nielsen, to the recovery of attorney's fees by a defendant. I do think the law is balanced as it stands.
Thank you, Mr. Dickinson. Mr. Wagner.
I will be brief and explain why I'm supporting the bill. I do hear the argument about a potential chilling effect if attorney's fees go both ways, but I will note that other jurisdictions, indeed, it's called the English rule. It's called the Canadian rule. It is the law from which we draw our source, has a presumption of reciprocity, has a presumption of fairness, and has a presumption that fees work both ways. We don't see in those countries that have been, frankly, practicing law that way a whole lot longer than we have in this country, that consumers are being denied remedies, that folks are not able to access the courtrooms, that the concerns expressed here, reasonable sounding though they are, in practice don't develop. At least that's my experience, and I think that's what we've seen around the world, where something other than the American law. Indeed, the English rule is in force. I would like to see us move more in that direction to balance the playing field. I commend the author for bringing this forward. I will note that I've got a couple of bills that do the same thing. Don't know what fate they will experience, but am looking forward to supporting this one because I think it's on the right track. Thank you.
Thank you, Mr. Wagner. I see we've been joined by another person at the podium. What is your purpose, please?
Mr. Chairman, I'm Rosemary Shahan, President of Consumers for Auto Reliability and Safety, and we oppose the bill because we believe it tips the balance too far against individuals and small businesses who have meritorious claims but are disadvantaged already.
Thank you for your testimony. Further comments or questions, colleagues? Mr. Wachowski, briefly.
I guess I have a question. Why is the good faith finding now inadequate?
If it would apply to both parties, I think it would be adequate, but it does not. It applies to the defendants. They have to demonstrate that there was lack of good faith. I'm just saying level the playing field.
Okay. That's different from the staff recommendation. The staff recommendation is saying if a court makes a finding that the plaintiff brought the action in bad faith, then there could be
But you have to demonstrate what was the bad faith. There is a burden on the defendant that is not imposed upon the plaintiff.
Okay. Thank you. All right. Are we prepared to move to Mr. Nielsen's close? Mr. Nielsen.
Mr. Chairman, I would just have to say somewhat with amusement, I rather enjoy these backhanded praises of President Reagan that occur on occasion, and now Governor Duke Majan, too. You know, one of the great things about both men, whom I knew very well, they were willing to admit when they made a mistake. And yes, I would beg the indulgence of the committee, and if you do not find favor, we will proceed, and maybe we'll have to do it like Senator Lockyer did several years ago, convene at Frank Fat's and get a napkin out and negotiate a tort reform memorialized on a napkin. Just appreciate your consideration, Mr. Chairman and members.
Thank you, Mr. Nielsen. I will note that neither past governor is here to defend himself. All right, let's move to a vote. Oh, is there a motion on the bill?
So moved if there wasn't.
It's been moved and seconded. Call the roll, please.
Fear?
No.
Fear, no. Wagner?
Aye.
Wagner, aye. Adkins?
No.
Adkins, no. Dickinson?
No.
Dickinson, no. Silva? Silva, aye. Huber?
No.
Huber, no. Huffman?
No.
Huffman, no. Jones?
Aye.
Jones, aye. Monning?
No.
Monning, no. Wachowski?
No.
Wachowski.
That bill has 3 votes, insufficient for today. Thank you, Mr. Nielsen. All right, now let's proceed to item number 5, Mr. Hill, AB 320. And I'll make a note, since this is audible in the building, that the next author would be Mr. Calderon if he would come to the committee. Otherwise, we'll proceed to committee members' bills. Mr. Hill.
Thank you, Mr. Chair and members. I authored this bill as a business owner because it will, in a small way, streamline CEQA and prevent agencies and businesses from unnecessarily dragged into lawsuits. As an environmentalist, I like it because it continues to protect CEQA. And as a legislator, I like it because it's good public policy. AB 320 clarifies that the real party in interest named in a California Environmental Quality Act lawsuit for a particular project are those listed by the lead agency as recipients of approval in the agency's notice of exemption or the notice of determination. Under current law, these recipients of approval are the indispensable parties which must be notified in case of a lawsuit. Unfortunately, in many cases, the entity bringing the lawsuit is unclear as to who those parties are. In some cases, project proponents use project managers who are designated as the project applicant, but are not always the actual recipient of the approval. This practice makes it extremely difficult, even for those who participated in the CEQA process, to know which parties must be included in a lawsuit. Failure to name all recipients of approval can lead to the case being thrown out, which is what occurred in 2007 in the Court of Appeals case in Imperial County. To prevent important cases from being dismissed, CEQA practitioners are forced to overname and serve parties who might or might not be considered indispensable to ensure that no one is being missed. This practice is a waste of time and money for everyone involved. AB 320 would eliminate the current inefficiencies by amending CEQA to clarify which parties must be named in litigation regarding a CEQA project. I proposed amendments to the committee to clarify that when applicable, a lead agency can name multiple recipients of approval in its notice of exemption and the notice of determination. With me today is Jenna Price of the Planning and Conservation League and Bill Yates of Kenyon Yates, LLP.
Thank you very much, Mr. Hill. Your first witness
Chair.
in support.
Hi, my name is Jenna Price. I'm with the Planning and Conservation League. We do agree with Mr. Hill. AB 320 would make CEQA less costly and time-consuming for all parties involved. Current law is not clear on exactly who must be notified when a lead agency's CEQA decision is challenged. Since a court can dismiss a case if an interested party is not notified, this confusion has led to plaintiffs being overly cautious and notifying a wide range of parties who may have only had an indirect interest in the case. This overabundance of caution slows down the court process and creates unnecessary hassle and costs for all the parties that were notified when they didn't need to be. AB 320 will eliminate this confusion, speed up the CEQA process, and cut costs to all parties involved. It makes clear that the interested parties who must be notified are the parties who received notice from the lead agency that their project was approved. These parties are listed on the lead agency's notice, so there will be no confusion over who should and who should not be notified of the court action. Thank you.
Thank you very much. Next witness in support. Seeing none, other witness. Oh, you're here in support?
Mr. Chairman and members, Bill Doring with Imperial County. We believe Mr. Hill has covered it all. We would ask for your support.
Thank you. Other witnesses here in opposition? In support? Oh, I'm sorry. There we have tardy supporters. Please.
Vern, excuse me, Vern Gehring with the California Native Plant Society. You've heard the testimony. We support this bill. Thank you.
Thank you.
Mr. Chair and members, Mark Thiessen with the Gualco Group on behalf of the California Council for Environmental and Economic Balance. We've supported this legislation in the past and supported it again this year and urge your aye vote. Thank you.
Michael Endicott with Sierra Club California in support. Thank you.
Thank you. Others in support? Are there witnesses here in opposition to the bill? Seeing none. Colleagues, questions, comments, motions?
Move the bill.
Bill's been moved and seconded. Questions? Mr. Wagner.
Briefly, my concern is that we are making it easier in this regulatory environment for CEQA challenges when perhaps we ought to be reevaluating some of those challenges and their anti-competitive effects. So I question the need for this bill now. But it also seems to me, and maybe Mr. Hill, if you could address, it seems to me this bill somewhat changes, again, a long-standing tradition in the law that the right parties, the indispensable parties necessarily be brought before the court, and kind of leaves it a little bit vague, ambiguous. Perhaps you can start with the wrong parties there. Perhaps we can fix that what used to be a jurisdictional problem down the road. And I'm curious why we want to go in that direction at this time.
Well, I don't know if we're going in that direction. What we're doing is clarifying that those parties of interest are identified right up front clearly so that other parties can join at a later time. But the key is that they are identified early on and that there's no problem at a later time, because what's happening today is everyone is named so that they're not missed. I think, is that your question, Mr. Wagner? I'm sorry, I may have not gotten it, but I don't see the problem that you're articulating.
Okay, my problem is that it looks to me as though, as we're saying, we are making it easier for CEQA suits to be filed without necessarily having all of the parties either named or identified, or they get identified later. It used to be, I mean, as you say, there might be a bit of a scattershot to make sure you don't miss anyone, but it is important that you not miss anyone. And so I'm curious why we want to narrow the procedures and frankly in distinction to what typically it seems to me courts do.
Well, we're narrowing the distinction because it's the accurate, and it creates the right person who would be named in that suit, not everyone else that would really have no involvement and are not the parties of interest involved in it. But if the attorney here from if Bill Yates wanted to comment further on some clarification, but I frankly think this is a much clearer and better way to proceed. Mr. Yates?
Thank you. Any further comments or questions? Seeing none, the bill has been moved and seconded. Mr. Hill?
I just respectfully ask for your aye votes, members. Thank you.
Thank you. Call the roll, please.
Fear.
Aye.
Fear, aye. Wagner. Wagner, no. Adkins. Adkins, aye. Dickinson.
Aye.
Dickinson, aye. Silva. Silva, no. Huber.
No.
Huber, no. Huffman. Huffman, aye. Jones. Monning.
Aye.
Monning, aye. Wachowski.
Aye.
Wachowski, aye.
That bill has 6 votes and is out. Congratulations, Mr. Hill.
Thank you, Mr. Chair.
All right, now we'll proceed, in the absence of Mr. Calderon, who in sign order would be next, we'll proceed to Mr. Wagner, item 6, AB 456. To be followed by Mr. Wachowski, number 4, AB 246. Mr. Wagner, good morning.
Good morning, and thank you, Mr. Chairman and colleagues. In distinction to what we've been talking about, I've got a riveting bill here. Civil Code, Code of Civil Procedure, Section 1281.5. So for the lawyers on the panel, this is a bill to fix an ambiguity in the Code of Civil Procedure. Section 1281.5 deals with arbitration of construction disputes when there is a right to a mechanic's lien. It allows the lien...
Bill's been moved.
Second.
The bill's been moved and seconded. The bill has no opposition. Mr. Wagner, you want to continue with your opening?
I am told to quit when I am ahead. I will take any questions, and we do have some witnesses here in support, but I will urge them to be quiet if there's no opposition.
Mr. Wagner, you are, however, accepting the author's amendments described in the analysis, correct?
Yes.
Very well. All right. Witnesses in support.
Mr. Chair, Phil Vermeulen, representing the sponsors, the engineering contractors, urge your aye vote. Thank you.
Mr. Chair and members, Mira Gerten here on behalf of the California Chamber of Commerce, also in support. Thank you.
Catherine Pettibone, Civil Justice Association, in support.
The bill's been moved and seconded. Colleagues, questions or comments for Mr. Wagner? Oh, by the way, I want to be sure. I noted that there was no opposition I know of. Anybody here wishing to speak in opposition to Mr. Wagner's bill? Okay. Now, questions, comments, colleagues? All right. Seeing none, bill's been moved. Mr. Wagner, you wish to close?
I urge your aye vote. Thank you.
Call the roll, please.
Fear.
Aye.
Fear, aye. Wagner.
Aye.
Wagner, aye. Adkins. Aye. Adkins, aye. Dickinson.
Aye.
Dickinson, aye. Silva. Silva, aye. Huber.
Aye.
Huber, aye. Huffman. Aye. Huffman, aye. Jones. Monning.
Aye.
Monning, aye. Wachowski.
Aye.
Wachowski, aye.
Congratulations, Mr. Wagner. That bill is out. Mr. Wachowski, item 4, AB 246. And again, I do want to note if Mr. Calderon is within earshot, we'd be delighted to have him present his bill as soon as he arrives. Otherwise, Mr. Wachowski to be followed by Mr. Dickinson, AB 622. Mr. Wachowski.
Chair and members, this measure corrects an anomaly in state law that prevents regional water quality control boards to refer cases to district attorneys and city attorneys. Under the current law, for civil cases involving violations of Porter-Cologne Act, only the Attorney General can act on behalf of the Water Board. The DAs and city attorneys can be referred cases that involve criminal activity, but not civil activity under Porter-Cologne. So that's the purpose. We've got limited prosecution. Many cases that have been brought to enforce violations of the Water Code are never filed. The district attorneys and the city attorneys routinely handle civil cases for violations related to inland and marine oil spills, fish and game protection, conservation laws, hazardous material violations, and then I've included in some of the analysis all these other areas they do. The bill will improve enforcement against polluters in water and protect water quality. I urge your aye vote.
Thank you, Mr. Wachowski. Witnesses in support of Mr. Wachowski's bill. Bill's been moved?
I don't think.
Sir, second? Okay, and there are some questions, but please, first witness in support.
Mr. Chair and members, Corey Salzillo on behalf of the California District Attorneys Association in support of the bill.
Thank you. Other witnesses in support of Mr. Wachowski's measure? Are the witnesses here in opposition to Mr. Wachowski's measure? Good morning. First witness in opposition, please.
Good morning, Chair, members. It is morning still.
It is.
Danny Merkley with the California Farm Bureau. We are opposed to this bill for some of the same reasons that we have been in the past. We have concerns, particularly in the agricultural sector, where district attorneys and the few city attorneys that would fit into this category do not have the expertise to understand, the same as the regional boards would, the violations that would come against them. In no way, shape, or form do I want to be misunderstood that we don't want to enforce against those that have violations, but we want the opportunity to be heard and understood by those that understand the particulars of this.
Thank you. Others in opposition?
Mr. Chair and members, Mike Dillon, representing the California Association of Sanitation Agencies. Pardon me for running down from upstairs. The current law allows we are opposed, we're the major wastewater agencies in the state. The current law allows the state attorney general to prosecute the civil actions, as you know, following referral by the regional board. We believe that over the years the system has worked well. As the analysis points out, our major concerns are shifting the authority for the judicial appointment from the regional board, to the executive officer. Our members occasionally find the executive officers can be quite unreasonable. We've recently had a situation involving a recycled water permit where the executive officer recommended a whole new permit for this one agency, and the agency appealed to the regional board and it was overturned. So that is one concern. And our other concern is that the consistency of enforcement. Currently, the regional boards and the Attorney General have attorneys and technical experts that deal with our issues, specialize in enforcing the complex system of water quality issues. So we just think it's not possible for 58, for example, district attorneys to have the expertise that the Attorney General's office currently has. So for those reasons, we oppose the measure.
Thank you very much. Others in opposition?
Yes, Steve Cruz, representing the California Building Industry Associations, for the reasons cited by Mr. Dillon and Mr. Merkley. And we certainly agree that the state system of water quality laws needs reform, but increasing the severity of civil actions against applicants is not the
Next witness in opposition, please.
Yes, Cindy Tuck with the Association of California Water Agencies, also in opposition.
Others in opposition?
Gail Delahant with Western Growers in opposition.
Valerie Naroth, California Chamber of Commerce in opposition.
Very well. We have questions from members of the committee. Mr. Dickinson, I think there was one more question after Mr. Dickinson. Did Ms. Huber have a question? Okay, Mr. Dickinson, go ahead.
The analysis indicates that the bill, and I didn't have a chance to track this down, would delete the requirement that the regional board or the state board hold a public hearing before the board would request the Attorney General to petition the Superior Court to impose, assess, or cover certain civil penalties. So I just first wanted to verify, is that actually is that deleted, the requirement deleted from the bill? And if so, did you intend that?
It doesn't require that they have a public hearing. They can, of course, have a public hearing. They could fire their executive director if they don't like what the executive director is doing, but it just allows them to go and take an action like they do on a variety of other environmental matters.
Well, I gather existing law requires them to hold a hearing.
That's correct.
That's right.
And so you're making it discretionary to hold the hearing?
Yes.
And so why are you deleting that as a requirement?
Well, it allows for increased flexibility with the water boards, and the water board actually has requested it. The state water board, that there's a variety of other areas that we regulate that allows them that flexibility to initiate the action civilly.
Okay, I support. I think giving district attorneys and the larger city attorneys the discretion to make these kinds of judgments and pursue these actions is reasonable. I would just encourage you to take a second look at that aspect of the bill.
Thank you, Mr. Dickinson. Other questions or comments for Mr. Wachowski? Excuse me. All right. Oh, Mr. Wagner.
Very quickly, if you would address a concern that we heard from Mr. Dillon about the possibilities of some inconsistent enforcements and 58 different district attorneys perhaps pursuing cases under different scenarios or circumstances. And the concern I have is district attorneys obviously are elected. A lot of city attorneys are elected. I'm a little bit worried perhaps about a grandstanding district attorney up for re-election who might like to make a name for himself or herself or something along those lines. Does your bill address any of those concerns or Mr. Dillon's concerns?
Well, we should be clear that district attorneys right now can prosecute criminally under Porter Cologne. So they have that. If there were some rogue district attorney that for some sensational reason wanted to do this, then they could do it. We're just extending that prosecution to civil penalties. So nobody's going to jail. We're just the idea is to correct the environmental problem that's there. The district attorneys already, I think part of the analysis, there must be 12 or 15 areas where district attorneys already have that expertise. There's a concern that the 58 different hodgepodge of rulings, we haven't seen that either in the criminal field or in these other hazardous waste, let's see, marine spills and things like that. It just hasn't arisen. So I don't know why that would somehow occur under Porter Cologne by just allowing these district attorneys to do the civil prosecution.
Well, do we have a problem with under-enforcement at this point?
Yeah, there's probably 2 handfuls of cases that are just not being addressed, and this will allow annually.
Thank you very much, Mr. Wagner. Further questions or comments? Is there a motion on the bill? Oh, it's been moved and seconded. Mr. Wajkowski, do you wish to close?
I urge an aye vote.
Thank you, Mr. Wajkowski. Call the roll, please.
Fear.
Aye.
Fear, aye. Wagner. Wagner, no. Atkins. Aye. Atkins, aye. Dickinson.
Aye.
Dickinson, aye. Silva. Huber.
No.
Huber, no. Huffman. Huffman, aye. Jones. Monning.
Aye.
Monning, aye. Wajkowski. Wajkowski, aye.
That bill has 6 votes and is out. Thank you, Mr. Wajkowski. We will now proceed to AB 620. Oh, Mr. Calderon arrived just at the right moment. For everyone except Mr. Dickinson, this is the right moment. So, Mr. Calderon, item number 7, AB 621.
Good morning,
Mr.
Chairman
Welcome.
and members. I'll try and be very quick. This is a bill that passed out of this committee probably in a broader form last year, and it relates to innocent third parties that are injured in an accident by someone driving a rental car. When they leave the country, it's difficult to find them, and many of them are insured by rental companies who offer insurance and offers coverage for innocent third parties. But unless you can find and serve the renter in another country somewhere, you cannot make a claim on the insurance. So what this bill does is it makes the rental company that offered the insurance, requires them to receive service of process so that a claim can be made even if the renter can't be found, and it limits recovery only to the limits of that policy. So it doesn't violate any rights on the part of the international renter. And that's what it does. And I ask for an aye vote.
Bill's been moved. Is there a second?
Second.
First witness in support.
Hello. Thank you, Mr. Chair. Christopher Dolan, the immediate past president of the Consumer Attorneys of California. This bill makes sense, and it makes sense for the following reasons. In the economic crisis that we're in right now, when Californians get injured by people from foreign countries where there is insurance sitting in the rental car company, the insurance can't be accessed, and the state, local healthcare facilities are being taxed with providing health care for these injured individuals when there is insurance that has been purchased that would pay for that. Many of the people who come in from outside the United States purchase this insurance because their insurance policies in their resident jurisdictions do not cover them in the United States. So they have this insurance that has been purchased that cannot be accessed. You may have read something about a yak in this particular bill. That was my case. I had a Tibetan national who had caused harm in the United States, we spent probably $5,000 to $10,000 trying to locate and serve this individual so as to get them to get their insurance policy into play.
What's the minimum wage for a yak?
You know, it was a $200 bill for a yak and a process server to go to a remote area and apparently serve this person. So what happens is, and I know the opponents say, well, we have the Hague Convention. Not all countries are signatories to the Hague Convention, and there are a number of different requirements in different countries. Now, the insurance companies have the address and information. They're in a contractual relationship with the people who rent these cars and buy the insurance. So they're in the best position to make sure that the insurance is available and the renter is notified of the pending suit. We were very careful to keep any claim within the policy limits of the policy that was available. So this actually provides a benefit to the foreign person who rents a car in the United States, because that person will not be exposed to any liability above the policy. And here in California, an insurance company, as long as they're within the policy of insurance, can make a decision to settle a claim on behalf of its insured without the insured's consent. This is designed to prevent hide and seek and to try to expedite the administration of justice and get the benefits of the insurance paid for to help the injured party and the local, state, and Medi-Cal facilities that are otherwise paying. Thank you.
Thank you.
We urge an aye vote.
Excuse me, Ignacio Hernandez on behalf of the Consumer Federation of California in support of the bill.
Thank you. Others in support of Mr. Calderon's measure? Are the witnesses here in opposition to Mr. Calderon's measure? Good morning. First witness in opposition, please.
All my friends.
Good morning, Mr. Chairman, members. Gordon Hart on behalf of Avis Budget Rent-A-Car. We have been working with the author and the sponsors for more than a year on this bill. It has certainly narrowed and many of our concerns have been addressed. We are committed to continuing to work with the author as it goes forward. As it stands, we remain opposed, but primarily because of the concern about if, in fact, we are unsuccessful in notifying the foreign renter that they have been sued and they then get a judgment against them without ever having known that they were sued, we're concerned that there could be liability against the rental car company in that instance, irrespective of the fact that the author and sponsor have indeed made good faith efforts to try to address that issue in the bill. We're confident we can continue to work with the author as it goes forward.
Thank you very much. Others in opposition?
John Ross on behalf of the Hertz Corporation, opposed to the bill in its form here today in committee, but encouraged that we should be able to get to a solution on this one.
Very good. Others in opposition?
Thank you, Mayor Gerton, here on behalf of the California Chamber of Commerce, also in opposition. Thank you.
Catherine Pettibone, Civil Justice Association, in opposition.
All right. Colleagues, questions or comments for Mr. Calderon? This is a bill I have dealt with this bill previously and have supported it before. Mr. White, you have a question?
I will be brief. In my analysis, I am told, and I guess I can address the author, that existing law, in particular Vehicle Code Section 17451, currently authorizes the Director of DMV to accept service for non-resident drivers. Why does that not solve the problem that you're attempting to deal with here?
Well, because they still have to notify the driver.
Right.
And
so
that's
does
the whole problem.
Thank you for the question. It's a good question. We have to still serve the driver. That is a very benign section of the law that does not relieve us of the obligation to track them down in the foreign jurisdiction and serve them pursuant to local law.
This bill does, though?
This bill allows us to serve the rental car company who has the insurance so as to get the rental car company to either have a contract with their insured to settle within the policy limit, so it would allow us to get to the rental car company and not have to traipse around the globe.
Right. But you don't.
But it only requires a rental car company to send notice to the most recent information that they have for the renter.
It substitutes the rental car company for the Director of DMV is essentially what it does, right?
No, that the law would not be changed as to the DMV. What it does is change the effect, because now there will be an effect of being able to access that insurance policy where there now is nothing.
Okay. And there is an existing Hague Convention. Why not exempt out of this bill countries that are signatories to the Hague Convention and follow standard treaty and international procedures?
Well, I didn't want to do that simply because we're talking about timing and injury. We're talking about an innocent third party, someone who was just minding their own business and they get injured. And there is a policy which is specifically designed for this purpose that is available. And the more difficult thing is, of course, finding whether it's under Hague or otherwise. And lots of times it's timing in terms of being able to get resources to pay for damages.
Okay. And I know that you've limited this law to the policy limits, but once the court has jurisdiction over the foreign individual, is it not possible for an additional lawsuit, another lawsuit, or, in fact, a damage award against the individual that exceeds the insurance policy's limit?
You have tremendous power, and by initiating this statute, the answer is no, because the court cannot violate the terms of this statute that are set forth by this great body.
Courts have never done that.
Well, they can. It's a jurisdictional issue.
Once you have assumed jurisdiction, then the full panoply of remedies ought to apply.
That's not correct. This body has limited the recovery of damages in a number of circumstances, including one that we have consistently opposed called MICRA. And therefore, the judges are limited to what they can award for general damages in those circumstances based upon legislative initiative. So it's quite clear that the limits that are set by this body cannot be circumvented by either myself, who's very creative, or a judge who themselves may think they can act outside the law.
Thank you.
Okay. Colleagues, questions or further comments? Seeing none, Mr. Wachowski?
I'll move the matter.
Bill's been moved.
Oh.
It's already been moved. It's well on its way. Mr. Calderon, do you wish to close?
Ask for an aye vote.
All right. Call the roll, please.
Fear?
Aye.
Fear, aye. Wagner? Wagner, no. Adkins?
Yes.
Adkins, aye. Dickinson?
Aye.
Dickinson, aye. Silva? Huber?
Aye.
Huber, aye. Huffman? Jones? Monning?
Aye.
Monning, aye. Wachowski?
Aye.
Wachowski, aye.
That bill has 6 votes and is out. Congratulations, Mr. Calderon.
Thank you, Mr.
All right.
Chairman.
Now, Mr. Dickinson, item number 8, AB 622, to be followed by AB 753 by Mr. Monning, and finally AB 887 by Ms. Atkins. Mr. Dickinson, good morning.
Good morning, Mr. Chair and members. AB 622 seeks to bring a small measure of openness, transparency, and accountability to grand juries when they perform their civil, and I want to underline civil, investigative function. This bill really is, in truth, born of my nearly 17 years of service as a county supervisor, interacting with, responding to, and dealing with civil grand juries. The bill really boiled down does 3, I think, fairly straightforward things. First, it requires that a grand jury meet with the chief executive or department head of an agency subject to its investigation at least 45 days prior to the issuance of its final report. The purpose of this is to give the department or agency head the opportunity to share with the grand jury any statements or issues of fact or other matters that would allow the grand jury, frankly, to get it right, not to put out information which is incorrect, which is clearly not any grand jury's intention. But the fact is, when a grand jury final report is made public, that determines the take on the issue. And it's better, in my judgment, to help the grand jury make sure it gets it right in the first place. The second element of this bill would require that when a grand jury hears testimony under oath from a witness, that the proceeding will be in public session unless it pertains to a personnel matter or some other confidential matter, and the grand jury can ask the supervising judge of the grand jury to close a proceeding under appropriate circumstances. Again, we're talking, as we were earlier this morning, about the presumption of transparency and openness in our legal proceedings. And I think some of the arguments we heard are pertinent here as well, that we ought to proceed on the presumption of openness in proceedings, particularly where people are being examined under oath, under penalty of perjury. Thirdly, the bill would require that when a witness is called to testify under oath, that they would have the opportunity to have counsel present with them in the hearing room. Now today, and historically, the fact is that a witness called to testify before the grand jury can have counsel standing outside the counsel room. This leads, I think, to a rather odd circumstance of a witness who wants to get legal advice from his or her attorney having to interrupt the proceedings, in effect, get up, walk outside the room, and talk to his or her lawyer. It seems to me it would much better serve economy, efficiency, and the flow of grand jury proceedings if the witness, who again is under penalty of perjury, has the opportunity to have counsel by his or her side. This bill does not give counsel an opportunity to participate in the proceedings by raising objections or by other affirmative actions, but simply to be there literally as counsel to the witness. That is the extent and nature of this bill. It does not preclude any civil grand jury from interviewing witnesses or interested parties in private, and conducting its deliberations in private, in voting on what its final report ought to look like in private. All of those activities will still be conducted in private. This is simply opening up those proceedings where there's a witness testifying under oath.
Thank you very much, Mr.
Thank
Dickinson.
you.
You have your first witness in support, please.
This morning, in the interest of economy and time, I am my witness.
That was very thoughtful of you, Mr. Dickinson. I wonder if your opponents expressed the same thoughtfulness. Are there any witnesses here in opposition? Good morning.
Morning. Mr. Chairman, members of the committee, I am Quentin Kopp, a retired California Superior Court judge and a person who's had about 40 years plus experience with civil grand juries. As a member of the San Mateo County Superior Court bench, I was the supervising grand jury judge for 30 months, which exposed me not to law review articles, but the actual means of operation of a grand jury in a civil context. And I might just note also that criminal grand juries have decreased in use in California almost exponentially in the last certainly 10 years and probably longer. I don't know of any DA in the Bay Area which uses or who uses a criminal grand jury, and I'll leave it up to the CDAA to comment on other parts of the state. And what the thrust of these changes in the now 131-year history of the civil grand jury in California would demolish the institution and the structure. Let me explain why I say that. To open up sessions to the public, which means the media, is simply going to discourage a common source of complaints to the grand jury, which are then acted upon by the grand jury. These are people, for example, who work in a city department or a county department or some special district, including a school district. They're not going to bother. and that is probably accountable, in my experience, for over half the matters which are recommended to the jury or requested of the civil grand jury for investigation. And investigations are keenly examined before the requisite number of grand juries votes to conduct an investigation.
Senator Kopp, your time has expired, so if you could conclude, please.
Well, all right, you'll have to pick it up. Mr. Troutman is a one-time civil grand juror. Take a look at the letter from the presiding judge of the San Francisco Superior Court. I just found out about this bill last Friday and was asked by the State Association to testify. But as more courts throughout the state find out about the bill, I suspect you're going to have letters similar to what Judge Feinstein has written. It simply isn't practical or feasible. There's one small aspect of it dealing with the interview of the department head prior to publication of the report. And even there, the language is imprecise and is contradictory to the present statutory scheme.
Thank you.
It talks about the subject of the investigation.
Thank you, Senator.
Let me pick it up there.
Yes.
My name is Bill Troutman. I served as the foreman of the 2007, 2008, and 2008-2009 Napa County grand juries. I am also involved in the training of 800 grand jurors throughout the state out of approximately 1,000 that are trained by the California Grand Jurors Association. I'm also the chair of our Legislative Affairs Committee, which keeps an eye on you guys. But let me just pick it up there. With respect to the first part of this bill, it's not necessary. Section 933.05 already requires that a grand jury meet with the subject of the investigation regarding the investigation unless the court determines that that would be detrimental. So the way the grand juries interpret that is if you're investigating a department, you have to meet with the department head. Now, there's no time limit on it, like Mr. Dickinson puts in his bill, but there is a provision that provides for that very thing to happen, and it does happen. The most egregious part of this bill, of course, is what Mr. Dickinson refers to as transparency. I think transparency is great for government. Grand jurors are enforcing the Brown Act all the time. But what grand juries are for is they're for accountability of government. They're a watchdog. They are to look to see whether the local governments are doing their job, economically, efficiency, and otherwise. And if you require that to happen in public, you are going to, as the California Supreme Court noted very eloquently, you're going to make it very difficult for the grand jury to be effective. And it's not what the Constitution contemplated when it made grand juries a part of the Constitution. But these are not my words. These are the California Supreme Court words. And they say, it hardly can be disputed that the encouragement of candid testimony and protection of witnesses and their reputation are best achieved when secrecy is maintained. And then they point out two things. One is whether or not a watchdog grand jury actually undertakes the weighing of indictments, secrecy provides the proper environment, the proper atmosphere in which to generate uninhibited testimony from county employees who might otherwise be intimidated by political or employment consideurations.
Thank you for your testimony. I'm going to have to ask you to conclude that point. It's been well over the time.
Okay, and they also say that secrecy serves to protect the witness's reputation.
Thank you. Others in opposition?
Mr. Chair and members, Corey Salzillo on behalf of the California District Attorneys Association for the reasons previously stated in opposition to the bill.
Thank you. Others in opposition to Mr. Dickinson's measure? Please.
On behalf of the whistleblowers throughout the state of California, we oppose this
Thank you. Others in opposition, please. I'm not sure that microphone is on. Can the sergeant please make sure it is? Please.
Emma Fervasi, former grand juror in Sacramento County, in opposition to this bill.
Thank you.
David Feldstein, former grand juror, retired professor of social welfare and public policy, strongly in opposition to this bill.
Thank you.
Jerry Jaggers, former grand juror and represents District 10 in Sacramento County. I am strongly opposed to this. I think it will literally gut the grand jury system. Thank you.
Thank you.
Yes, Joe Maloney. I'm the president of the Sacramento County Grand Jury Association, and we strongly oppose this measure.
Thank you.
Joseph Perrin, a member of the Sacramento County Grand Jury, adamantly oppose this measure.
Thank you very much for your testimony. All right, colleagues, questions or comments for Mr. Dickinson? Wagner.
Well, we've noted before when Republican governors were involved, let me note that a Democrat governor has vetoed a similar measure. And I think, given the lateness of the hour, for all the reasons we've heard, I regrettably cannot support this bill.
Thank you very much. Mr. Rakowski had a question?
I'll just move the matter.
Okay. The matter has been moved and seconded. Mr. Dickinson, I think it would be important to respond, and I take it would be in your close at this juncture, to a key thrust of the opposition's arguments, which is that this will chill whistleblowers from effectively participating in the process of holding governments accountable.
Thank you.
And please, why don't you close, including but not limited to that point.
Thank you, Mr. Chairman. Let me just say that this will not impede or chill grand jury investigations. Please keep in mind that all the proceedings of the grand jury, other than those limited to testimony under oath, would remain private and secret. So investigations, as Senator Kopp referred to, would be carried out in private. Interviews of witnesses not under oath would be carried out in private. The deliberations of grand jurors would be in private. It is only when a witness would be sworn under oath, penalty of perjury, that the proceeding would be open. And for good cause, even the grand jury could ask the presiding judge, the supervising judge of the grand jury, to close that. The notion that whistleblowers or others would be deterred from going to the grand jury, I think, is misplaced. First of all, if you are a whistleblower, the practical reality of it is your identity is known to the agency that you are reporting. That fact is the public does have a right to know, and we presume it. I'm not surprised by those who oppose this, because those who operate in secret traditionally do not want their proceedings exposed to public light. But the real thrust, the real concern here is whether members of the public will be deterred from going to a civil grand jury. And I would argue to you that will not happen, because they still will have a stake in reporting those things that they think are misdeeds or inappropriate, and they can be protected by the secrecy that will remain for the grand jury, notwithstanding the provisions of the bill. I'd ask for an aye vote.
Thank you very much, Mr. Dickinson. Call the roll, please.
Fear?
Aye.
Fear, aye. Wagner? No. Wagner, no. Atkins? Aye. Atkins, aye. Dickinson?
Aye.
Dickinson, aye. Silva? Huber? Huffman? Aye. Huffman, aye. Jones? Monning?
Aye.
Monning, aye. Wykowski?
Aye.
Wykowski, aye.
That bill has 6 votes and is out. Thank you. Mr. Monning, the penultimate matter on our agenda today is item number 9, AB 753, and then we'll conclude with Ms. Atkins, item 11, AB 887. Mr. Monning, good morning. Well, actually, good afternoon.
Well, good afternoon, Mr. Chair and members. I want to thank all of you for your patience and this opportunity to present this important piece of legislation today. I also want to thank the witnesses for their patience. I'd like to start by accepting the committee's suggested amendments outlined in the analysis. AB 753, known as the Rachel and Jacqueline Houck Auto Rental Safety Act, will prohibit rental car companies from renting vehicles which are subject to a federal safety recall once the companies have been notified by the manufacturer that the vehicle is the subject of the recall. Once the vehicles have been repaired, the car can be rented out once again by the agency. Existing federal and state law has a loophole that allows rental car companies to rent out vehicles under safety recall, even though new car dealers are prohibited from selling new cars that are under the same recall. Under federal law, motor vehicles are subject to mandatory safety recalls for two reasons. They have a defect that poses an unreasonable risk to the public, and they fail to comply with mandatory federal safety standards. This bill is important to ensure that the Houck tragedy, whereby Carol Houck's daughters, Rachel and Jacqueline Houck, were killed while driving a recalled PT Cruiser rented from Enterprise, never happens again. Approximately 1 month before the Houck sisters were killed, Enterprise received a notice from Chrysler that the PT Cruiser had a defective steering component and was prone to catch fire. Despite the warning, Enterprise rented the car to 3 other customers before renting the PT Cruiser to the Houck sisters. I want to acknowledge that some rental car companies have indeed changed their policies as a result of this tragedy, but legislation is still necessary to ensure that all consumers are protected when they rent a car in the state of California. We need to ensure that rental car companies don't become complacent with their policies and rent out recalled cars, as well as to ensure that smaller rental car companies who do not have such policies in place do not rent out recalled cars to retain their smaller customer base. I know the opposition believes that all safety recalls should not be treated the same. The facts are federal regulations treat all safety recalls the same. If there wasn't a safety risk, then they would not be the subject of a safety recall. The manufacturer could issue a technical bulletin if it was not a safety recall. I do not believe it is our place as a state to second-guess a federal safety agency whose primary mission is to protect driver and rider safety. Lastly, on March 31st, a piece was published in the New York Times that NHTSA, the National Highway Traffic and Safety Administration, was expanding its investigation into whether millions of rental cars are being repaired quickly. NHTSA is requiring specific information from rental car companies regarding this issue. By NHTSA taking this step, it shows us that they are also concerned about this issue and want to know more about the various companies' policies. Consumers need to know that when they rent a car, that the car is safe. AB 753 will help protect consumers. I have several witnesses here to testify in support. First, Mr. Chair, I'd like to invite Ms. Carol Houck, the mother of Rachel and Jacqueline, for her testimony.
Good afternoon. Welcome to the committee. It's on.
Thank you very much, committee. I want to first give my profound appreciation to Assemblymember Monning for naming this bill in memory of my daughters who didn't have to die. This bill is important because it closes a loophole. And this loophole has allowed the rental car industry to avoid the federal mandates under recall laws that are mandated for the new car dealers and the manufacturing industry. They are in the business of making profit over the consumer, over the renting of these cars. Yet They oppose this bill because of the economic consequences they're concerned about. I'm not concerned about the state of their economic well-being, nor should any other consumer who gives their good money to get a safe vehicle. The rental car industry is the single largest source of automobiles on America's highways. My daughter's lives ended when they lost control of the car that they had rented from Enterprise for exactly the reason it had been recalled, a fire under the hood. My daughter, Rachel, 24 years old, and my second daughter, Jacqueline, age 20, plowed head-on into an 18-wheeler. This could very well have been an incident where they had plowed head-on into a van carrying a family of 5. Why does the industry oppose this? Committee, this is not rocket science. This should not be a partisan issue. This concerns consumers and the safety of consumers. This does not concern the well-being of these corporate giants who enjoy a lot of profits over a very healthy industry.
Thank you for your testimony. Next witness in support.
Mr. Chairman and members, I'm Rosemary Shahan, President of Consumers for Auto Reliability and Safety, and we're the sponsors of the bill. And we greatly appreciate Assemblymember Monning's offering it and Carol Houck's willingness to speak up. And we would note that she was exceptional in that she refused to sign a confidentiality agreement. And typically in cases like this, that's what happens. There's confidentiality. And I asked the sergeant to distribute to the members a statement issued yesterday by the National Highway Traffic Safety Administration. I asked him to help clarify, because I know that the industry is asking for a 2-tiered safety recall system, which would be unprecedented regarding any consumer product, let alone this one, which is the most lethal consumer product in the country and in our state. And basically, what NHTSA said was that they believe that rental car companies have a responsibility to provide safe vehicles to their customers, and that all safety recalls resulting from defects present an unreasonable risk to safety, and that the agency believes it's inappropriate to suggest that some defects are not risky enough to require repair. For the safety of the motoring public, all recalled vehicles should be fixed promptly. And that's what the bill would do. It simply require rental car companies, once they receive notice that there is a safety recall, to act promptly. And I would note that there's already an existing provision in the federal law that says if a manufacturer believes that the defect is inconsequential and does not impact safety, they are permitted to petition the National Highway Traffic Safety Administration not to require a recall. And they very rarely do this. Almost all the compliance with the federal statute is voluntary compliance with the mandate for the recall, for the simple reason that usually it's quite obvious that the vehicle is unsafe. Usually the safety recalls involve things like seatbelts that don't work, airbags that don't work,
Thank you for your
fires,
testimony.
etc.
Thank you. Others in support.
Hello, my name is Elisa Odebashian. I'm the director of the West Coast Office of Consumers Union, the nonprofit publisher of Consumer Reports magazine. We're in strong support of this bill. I'll just add.
Actually, if you would, that risk sort of name and
Okay.
affiliation. So thank you for your testimony. Others in support.
Christopher Dolan, immediate past president of the Consumer Attorneys of California, in support.
Thank you. Others in support of Mr. Monning's bill.
Offer your name and association.
Yes, my name is Ben Kelly. I'm on the board of directors of the Center for Auto Safety, which is a national consumer protectionist organization. I'm also a member of the adjunct faculty of Tufts Medical School. I'm here in the capacity of an expert on motor vehicle safety issues and defect recalls in particular, and I gather that's to answer questions.
Yeah, just to indicate your support for
Yes,
now.
and I do support this
Thank
bill
you.
very strongly.
Are there other witnesses here in support of Mr. Monning's bill? Sir, please just indicate your name and your support, please.
My name is Carl Nienauber. I'm a concerned, outraged citizen that this is happening, and I urge you all to vote for this
Thank you.
bill.
Now, are there witnesses here in opposition to the bill? Good afternoon. First witness in opposition, please.
Thank you, Chairman, committee members. Thank you, Bill. My name is Tom Laffey. I'm the General Counsel for Enterprise, and I'm here speaking on behalf of our parent company and our regional subsidiaries that rent cars, including the 3 that operate in California. I know this is a matter of tremendous importance, and I appreciate the passion and the energy on the other side because I know it's sincerely felt. It's a matter of a great deal of interest. I personally have been to Washington, D.C. on multiple occasions in the last 6 months to meet with the Federal Trade Commission, which is looking at this issue, to meet with the National Highway Transportation Safety folks, NHTSA, to talk about the issue. As was already mentioned, we're providing information to them. They're looking at the issue. We've recently provided them information that reflects that the rental car companies generally get about 90% of all recalled vehicles fixed in the first 30 days. I think when they're all their deliberations and their study are concluded, you're going to find that that is a record that far exceeds any other class of vehicle owners by a considerable measure. We oppose this bill. We oppose it because we believe it's not necessary, it's not workable, and it's discriminatory. Recalls are not all alike. The bill uses as the trigger for an obligation to not rent the vehicle, and per the amendment that I saw last night for the first time, an obligation to go try to get them back from people who have them on rent. The fact that a recall notice has been issued by the manufacturer. Recall notices are issued by manufacturers, generally speaking, over the last 20 years on a voluntary basis, and they come in all different sizes and shapes and for all different kinds of reasons. And I can give you just 2 quick examples that I think make the point. But I think the important thing to remember is that nowhere in the Federal Motor Vehicle Safety Act that NHTSA administers is there any requirement or obligation that people who receive a recall notice do not continue to drive their car. In fact, I would submit that the expectation is that people will continue to drive their car. No provision in the Act is made for compensation to an owner who is no longer able to drive his car. And literally, except in rare instances that I'll speak to one in a moment, the expectation is that you'll make an appointment with a dealer and you'll take it in and you'll likely drive it to the dealer. The fact is that we get recall notices of all sorts. The manufacturers are obligated to include in the notice an evaluation of the risks to motor vehicle safety and a statement of the precautions, if any, that the owner should take.
Thank you for your testimony. If you'd like one concluding sentence, and then the next witness, please.
Well, I would say one more thing, and then I'll pass it on. I in no way mean to minimize the tragedy that occurred to the Hauk family. And I've got 3 daughters myself. We personally feel I can't imagine the pain and the loss. But we've had in our industry in excess of 3 billion rental days since 2004 with no similar incidents whatsoever. And frankly, none that occurred before.
Thank you.
And I don't believe this single incident warrants this particular.
Other witnesses in opposition?
Mr. Chairman, members of the committee, my name is Robert Muse. I'm the Vice President of Government Affairs for Avis Budget Group. To follow up on what Tom was indicating, all recall notices really aren't the same. And I'll use one as a very good example. We received a recall notice with regard to a pedal entrapment issue where the manufacturer said the gas pedal would get stuck. The reality is if you removed the floor mat from the driver's side, that impediment is no longer there and the car is truly safe to be driven. But the recall notice actually says the repair to the car is a new gas pedal. So this bill seems to be putting in play intermittent and remedial measures that can be taken that won't be allowed to be taken and deprive people of an opportunity to rent a car. You know, Avis Budget Group has had recall policies where we've grounded cars since at least 1983 when we get the notice. We take it very, very seriously. We have a team of people that review it. And in fact, we are consumers like everybody else, and we have to check with the manufacturer and say, what do you really mean by this? We've indicated to Mr. Monning on a number of occasions that the federal government is indeed looking at this, the Federal Trade Commission, NHTSA, Mr. Schumer, and the U.S. Senate. We've encouraged people to come with us and have an open dialogue on the federal basis because this really is a federal issue. our cars go interstate commerce. NHTSA is governed by federal rules and regs. It should really be done at the federal level. Finally, we find it really odd that public safety is really not the issue here. It's really a rental car issue. If the Houks, unfortunately, were in a limousine, this would be a limousine bill. If they were in a taxi cab, this would be a taxi cab bill. You shouldn't single out one single industry that does a very good job, with one exception, in recalling its vehicles and getting them fixed, and not deal with the other issues that sit out there on the highways.
Thank you for your testimony. Other witnesses here in opposition to Mr. Monning's bill?
John Ross on behalf of the Hertz Corporation. I would compliment your committee staff on what I thought was a pretty balanced and fair analysis of this issue. It's complicated, and we're willing to keep working if there's a desire to work towards a solution.
Thank you for your testimony. Others in opposition?
Teresa Cook on behalf of the California Travel Association, also respectfully opposed.
Mira Curtin here on behalf of the California Chamber of Commerce, also in opposition. Thank you.
Thank you. All right, colleagues. Questions or comments for Mr. Monning on his bill? Mr. Wagner?
If I may, a couple. I am struck by a couple of the witnesses who have said that the federal government is looking into this and that there has been one admittedly horrible and tragic incident that prompted this back in 2004, nothing before that, nothing after. So I guess I would ask, is it not appropriate that we leave this to the federal government? And I've got a couple of other questions that kind of will impact some of the federalism issues, but let me just throw that out for starters.
Okay. Well, thank you, Mr. Wagner. First of all, while I fully support a federal solution to this, I don't think we can wait for the next Hauk family to be stricken with a preventable tragedy with no guarantee when and how and if the federal government will get to this. California is one of the largest rental car markets in the country, I would submit in the world. With respect, I know a number of people have suggested, well, this is a tragic incident, but should we make policy based on one tragic incident? What we don't know is cases that were settled out of court with a confidentiality provision based on similar tragedies or other accidents. Also, I don't think we as a state, we as a committee who are empowered with the protection of renters should miss an opportunity to enforce what is already the standard. The federal government has recognized that when a vehicle is recalled, it should be removed from service. And just on that point, there was the suggestion that owners receive notices, owners of vehicles, they often wait weeks, months before they get it fixed. There's a profound difference here. When somebody goes into a rental car agency, their assumption and the contract they enter into is that they are renting a safe vehicle. The owner can choose whether or not they want to respond to a safety recall that they receive in the mail. Unfortunately, with a rental car customer, they're not receiving the notice. They're not giving the choice to determine whether or not they want to drive a vehicle that is the subject of recall. And I would submit that 99.9% of rental car customers, if given the choice at the counter, would you like to rent today a car subject to a safety recall or one that is not subject to a safety recall? That's what this bill serves to enforce, is the protection of a trusting consumer public.
Well, then why not have a bill that gives them the choice as opposed to one that mandates it?
Well, it's a fair question. It was raised in some of our earlier conversations. Anyone who has gone into a rental car agency and provided your initials as you're rushing from the airport to your appointment, nobody reads the fine print. If you had a waiver in there that required your initial, 99% of renters would initial that to get the keys, to get out to the parking lot. How many renters do you know who sit down with a 6, 8, 10, 12-page contract and read the fine print? That's not the way we provide consumer protection.
Let me ask, getting back to the sort of federal questions, I'm a little unclear on the bill. if I rent a car in Nevada that's subject to a recall, is the rental company allowed to rent it to me if they know I intend to drive it into California, or vice versa, if they know I intend to drive it from California into Nevada? How does this law apply?
Well, this law should protect, ultimately, all consumers in all 50 states should be protected. Waiting for the federal government to do it doesn't satisfy our need in California. So to respond to your question, if somebody rents the vehicle from the agency and their destination is California, I don't think you'd hear a single rental car agency say, well, we're going to rent one vehicle in Nevada and then we'll rent only safe ones in California. That's not the position of the rental car agencies. They are positing that they only rent safe vehicles. So you should be renting a safe vehicle in Nevada, whether it's headed to California or Tennessee, just as we seek California rental agencies, big and small, to play by the same rules. If they are in fact protecting the safety of the renters, this will create a level playing field with maybe smaller companies that are working on smaller margins.
So you're expecting Hertz or Enterprise or whomever, if this law goes into effect, that in Nevada or in Tennessee or in Delaware or Maine, they're going to have the same rule and not rent those vehicles?
I would think they should. If not mandated by those states, then in the spirit and compliance with a vehicle that maybe starts being rented in California or its destination is California. The issue here is safety, and I don't think we should mitigate safety to wait for the next Hauk tragedy to happen.
If a vehicle is rented and then is subject to a recall, must the rental company track down the owner and take the vehicle back from them?
One of the amendments that I accepted in dialogue with the committee would be a notice provision. If somebody has rented a vehicle, they've taken their family to Disneyland from the LA airport, and the company receives notice of a safety recall, we would expect the company to use good faith efforts and document their efforts to contact that family based on the cell phone number they left when they rented the car.
If they rent the car in California and take it to Las Vegas, must the rental company go to Las Vegas to retrieve the car?
Absolutely.
Okay.
I mean, under what circumstance do we want to allow the unsafe car? Is there a state where we're going to provide haven for an unsafe vehicle?
Okay. I'm looking at the ramifications of your bill. I mean, that's a fair question. And then I guess, to pick up on something one of the other witnesses said, this is a rental car company because of a very tragic circumstance, a rental car bill. Is there a reason we don't apply the same standard to taxi cab companies and to limousine companies and, for example, to the state of California, which has a very large fleet of cars? If it's a safety issue, what's the limiting principle that says only rental cars?
I'm open to expanding the scope of this, is the simple answer.
Okay. Thank you.
Thank you, Mr. Wagner. I'd like to just to ask a quick question of witnesses who, if you don't have an answer, just say, I don't know that for sure. There was a report that I understand, a study that was initiated by NHTSA that examined the pace with which rent-a-car companies responded to safety recalls by actually having the vehicles repaired. And at least one report, a news report in the Los Angeles Times, I believe, indicated that Hertz, pursuant to the study, Hertz fixed about a third of its vehicles within 90 days. Avis and Budget, 53% within that same time frame, and Enterprise, 65%. Simple question, are those figures wrong?
Yes.
Okay, and are they wrong? Is the study erroneous, or was the news report erroneous?
The way the study was conducted didn't take into account the fact that vehicles don't remain in our fleets all that long. So the manufacturers reported cars that they sold, but by the time a recall was launched, had already been disposed of from our fleets.
I would, rather than going through an exercise of speculation here, I would appreciate submitting to my office what you would consider to be the actual analysis of the time frames within which repairs are conducted and not. Let me just say for the record, I wouldn't want to be driving a rental car that had been subject to a recall and not know it. And if these numbers are anywhere close to accurate, they are deficient. But I'll look forward to receiving the actual data if you think there's a disparity, and then I'll contact NHTSA and see why they think the study was accurate and your report is not. All right, other questions or comments from members of the committee? Mr. Huffman.
I want to thank you for this bill, Mr. Monning, and I especially want to thank Ms. Houck for her courage in being here and taking up this cause. And I think this bill and this tragedy is really the poster child for just why secret settlements are so pernicious. It's why we sit here, and there's a claim that this is the only time anything like this has ever happened, and we have no way to verify that. So we know that most folks in this tragic situation take the money, sign the confidentiality, and none of us ever know about it. But you've enabled us to shine a very bright light on a clearly problematic practice in this industry, and it's something that I think we can make some much-needed improvements on. So thank you.
Okay. All right, colleagues. Mr. Dickinson, quick comment?
Quick comment. I too want to thank Mr. Monning for this bill. I think that when any of us go to rent a car, we have an expectation that we're getting a safe vehicle. And the testimony that the repairs occur within a very rapid time frame, it seems to me, leads to the conclusion that the burden here of this bill is minimal. So it's in the interest of rental car companies, it seems to me, as well as all the rest of us, to make sure that we do get safe cars when we rent them.
Thank you. All right, Mr. Monning, as you close, I do want to say I was encouraged by the comment from Mr. Ross, actually, who indicated that there was a continuing discussion to refine the bill that would be ongoing from this point forward. And Mr. Monning, is that your understanding as well?
I'm open to further dialogue with all stakeholders. My concern, the bottom line, is protection of consumer safety. And if we can find a path that achieves that goal without compromising consumer safety, I welcome further dialogue.
Very well. Can we take that as your close, or would you like to elaborate further?
I think you can take that as my close. You've been generous with your time, committee. Thank you.
Thank you very much. The bill's been moved.
Second.
And seconded. Call the roll, please.
Fear.
Aye.
Fear, aye. Wagner. Wagner, no. Adkins. Adkins, aye. Dickinson. Dickinson, aye. Silva. Silva, no. Huber. Huffman. Huffman, aye. Jones. Monning.
Aye.
Monning, aye. Wachowski. Wachowski, aye.
That bill has 6 votes and is out. Out as amended. Congratulations. Now, Ms. Atkins, please. Ms. Atkins has not been feeling well, and we really appreciate your patience, Ms. Atkins. It just happens that in numerical order, this bill ends up being the last one we consider. Well, good afternoon.
Thank you, Mr. Chairman and committee members, and I really do appreciate your hanging in there with me. And I also appreciate that you'll forgive me if my voice starts to falter. AB 887, the Gender Non-Discrimination Act, affirms what is true about California. We do not discriminate, and everyone is entitled to equal protection under the law. This bill adds the terms gender identity and gender expression to selected non-discrimination laws where only the term gender appears currently. AB 887 ensures that all Californians, including transgender people, are protected equally under these laws. Gender identity refers to one's internal, deeply felt sense of being male or female, and gender expression refers to one's gender-related appearance and behavior. Under existing law, the definition of gender already includes a person's gender identity and gender expression, whether or not stereotypically associated with that person's assigned sex at birth. As such, this bill, AB 877, does not confer any new legal status or protections. Instead, what it does is it makes our non-discrimination laws stronger and clearer. Current non-discrimination laws are often confusing to those who bear the responsibility of ensuring that these laws are enforced because they are under-descriptive. Californians should be treated equally by specifying gender identity and gender expression in addition to gender. AB 887 makes our non-discrimination laws easier to understand and to follow for those who employ, house, insure, and educate Californians. It also helps transgender people better understand their protections under the law. And with me to testify today are Mario Guerra, Government Affairs Director at Equality California, and Mason Davis, Executive Director at the Transgendered Law Center.
Thank you for hanging in there, Ms. Atkins. First witness, please.
Good afternoon, Mr. Chair, members of the committee. My name is Mario Guerrero, and I'm representing Equality California. Equality California is a sponsor of AB 887. We thank Assemblymember Atkins for her leadership in authoring this bill. Equality California has successfully advocated for the passage of over 70 bills aimed at protecting the rights of lesbian, gay, bisexual, and transgender Californians. AB 887 is a great addition to these kinds of bills. As stated, the bill further strengthens civil rights protections. AB 887 takes existing protections based on gender identity and expression and enumerates these protections, these protected categories in non-discrimination laws. By enumerating these protections, people will more clearly understand California non-discrimination laws. And I'd like to point out that more than 100 cities across America provide clear non-discrimination protections based on gender identity, including Los Angeles, Sacramento, San Francisco, Oakland, Berkeley, San Diego, San Mateo, to name a few. In closing, I want to highlight the use of the term by some opponents, gender confusion. This term is extremely disrespectful to the transgender community. We respectfully ask for your aye vote.
Thank you. Next witness in support.
Good morning, Mr. Chair and members of the committee. My name is Mason Davis. I'm the Executive Director of the Transgender Law Center. At its root, AB 887 is a simple cleanup bill that is nonetheless absolutely critical for transgender people throughout the state. The discrimination that transgender people face is literally life-threatening. It affects our physical and our economic security by denying us opportunities in everything from housing to jobs. Currently, transgender people are technically protected from discrimination under California law because the definition of gender includes gender identity and expression. Unfortunately, this setup results in confusion and creates barriers in implementation and enforcement. For example, most employee handbooks do not include the definition of gender, making many transgender people unaware of the rights that they have. Our legislature acted with the best of intentions when it extended a range of non-discrimination protections to transgender people over the past 10 years. Unfortunately, a bleak reality remains. Despite our current laws protecting us against discrimination in housing, employment, public accommodations, schools, insurance, and other critical areas, we still have alarmingly high rates of discrimination. Surveys that we've conducted show that 67% of transgender people in the state have experienced employment discrimination. And yet, very few transgender people make complaints, largely because they don't know that they have any rights. Further, by making these protections more explicit, employers and others would better understand non-discrimination laws, which in turn would increase the likelihood that employers would work to prevent discrimination and will respond more effectively and expeditiously the first time discrimination occurs. All hardworking people in California, including transgender people, should have the opportunity to earn a living and provide for our families. The Gender Non-Discrimination Act would strengthen existing protections and ensure that confusing legal language does not come between transgender people and our rights. People who don't fit narrow gender stereotypes are marginalized or ignored at best and bullied and harassed at worst. We need AB 887 to reduce this discrimination. Thanks for your consideration of this bill.
Thank you. Others in support? Given the hour, if you would state your support quickly, please.
Christopher Dolan, past president of the Consumer Attorneys of California and civil rights lawyer handling these cases, urging a strong support.
Carolyn Laub with Gay Straight Alliance Network, urging your support so student handbooks and school non-discrimination policies will make sure students know they're protected.
Adam Price, I attend Redlands High School, and I support AB 887.
Benji Delgadillo, a 16-year-old transgender high school student. I strongly support AB 887 to ensure my school safety.
Isaiah Bisaria, a high school senior from Los Angeles County. I strongly support this bill.
Odie Sims, Pomona, college student, transgender, completely and enthusiastically supportive.
Dave Reynolds with the Trevor Project, and we're here in support of 887 to clarify codes and reduce discrimination which impacts psychological well-being. Thank you.
Violet Nichols here is a proud trans woman who wants to support this bill.
Tina Everhart, National Association of Social Workers, California chapter, but more importantly, a mother of a son who is part of the LGBT community. We support this bill.
Ben Hudson, Executive Director of the Gender Health Center and a transgender Californian, strongly in support of this bill.
Enrique Manrez, member of the LGBT community, and I strongly support this bill.
Tiffany Mock on behalf of the ACLU, thanks for your leadership, and we support the bill.
My name is Ty Polskamp. I'm an out transgender man working here in Sacramento, and I strongly support this bill. And I'm going to go ahead and voice interpret for my friend here. Hello, my name is Kyle Cole. I live here in Sacramento, and I'm gay. And that, AB 887, we support that. Thank you.
Thank you for testimony. Are the witnesses here in opposition to the bill?
Yes.
Please come forward.
Good evening, members. My name is Paulo Silva. I'm the Legislative Director with Capital Resource Institute. And first, I would like to give a shout out to the high school and college students. I think it's important that the youth be involved when it comes to the legislative process. But I'm actually here to testify against 887. Let me tell you a little story. When I worked here in the Assembly, I was often tasked with the duty of researching for bills and coming up with a ledge packet. I would have to go through, the penal code, education code, and several different codes, and it was often more often than not confusing. The reason why I tell you this story is because according to the very analysis by the committee staff, existing law, and actually as was stated by the second witness, existing law defines gender as sex and includes a person's gender identity and gender-related appearance and behavior, whether or not stereotypically associated with that person's assigned sex at birth. So this is already part of California law. Furthermore, it says here that while the Unruh Act and other anti-discrimination statutes protect classifications such as transgender in California, the fact is that not always known by those that the law is intended to protect, or by employers, housing authorities, and others vested with the responsibility of ensuring anti-discrimination laws are enforced. It seems to me that the problem is enforcement, not necessarily clarification, even though the author says that she introduced the bill for the purpose of ambiguity and uncertainty. No, the law is clear. The law already protects individuals who gender identity and gender expression, as was stated by one of the supporters and as stated by the committee analysis of your very own consultants. So for that reason, this is more than anything will cause more confusion, if you ask me, because now you have duplicative legislation, basically bills adding to code, and we all know California's code is confusing enough already. So please, I urge your no vote. Thank you.
Testimony. Others in opposition?
Hi, I'm Davi Rodriguez, and I want to state first that this is not an opinion of Save Our State, which I was exhibiting earlier. This is not on our agenda, but rather as an employer or prospective employer, should business ever pick up again for me. This bill forcibly requires an employer to allow deception in the workplace. So, an employee can misrepresent their gender to other employees and the employee's customers or patients or what have you, and the employer will be required to allow it. What may come out of this is employers having to display another sign in their business that notifies other employees and their customers or patients, what have you, that under California law, employees may be misrepresenting their gender, simply to protect themselves. I would urge you to consider that deception is really not, it seldom has a good outcome. And I would point to you the Gwen Arujo case. She was murdered, not primarily because she was gay, but she misrepresented herself to these boys who then became enraged after the truth came out. I don't have anything against gay people. I may not like it, but I don't want to. I don't hate them. I don't want to kill them or anything like that. It's just not in my nature. But to be signing on to this and forcing an employer to engage in the deception to allow it is just simply wrong. Also, this bill does not address the intent of their deception. So when it comes out later, the employer gets sued for saying he allowed this person in here to misrepresent themselves as a female or a male to another employer or a customer or something like that. there is nothing in the law that says that it was wrong for that person to do it.
Thank you for your testimony.
Okay.
Others in opposition? Seeing none, as a supporter of the bill, is there a motion on the bill?
I move the bill.
Is the bill seconded? This bill's been moved and seconded. Are there questions or comments for Ms. Atkins? Mr. Monning.
As a co-author, I just want to thank Ms. Atkins for bringing this forward and for the witnesses for the work that you do in trying to create equality for all people in California. Thank you very much.
If I may, Mr. Chairman, I'd like to be added as a co-author.
Very well. All right. Questions or comments? Other? Seeing none, Ms. Atkins, wish to close?
I would respectfully ask for an aye vote.
All right. It's been moved and seconded. Call the roll.
Fuhr.
Aye.
Fuhr, aye. Wagner. Atkins. Atkins, aye. Dickinson.
Aye.
Dickinson, aye. Silva. Silva, no. Huber.
Aye.
Huber, aye. Huffman. Huffman, aye. Jones.
You're right.
Monning.
Aye.
Monning, aye. Wachowski.
Aye.
Wachowski.
Congratulations. That bill is out. We have no further business before the committee. Nothing is on call. If members wish to add on to bills where they didn't have the opportunity to vote, now is the time to do so. We are adjourned.